Hello, everybody, and welcome once again to many of you. Welcome to Cyber Week 2020. We're on our fourth day. My name is Noam Ebner. I'm a professor at Creighton University in Omaha, Nebraska. I teach in the Negotiation Conflict Resolution program, and I've been working in the ODR field for about 15 years in practice, teaching, and research. That is nothing compared to our speaker for today, John Zeleznikow. Professor Zeleznikow has been teaching. John, you're going to have to provide the number. I'm going to go ahead and guess 50.
Well, I suppose 48. So yeah, 50 is pretty close.
So modest. So Professor Zeleznikow has been teaching for the past 48 years at universities around the world. His current affiliation remains Victoria University in Melbourne, but I know you are affiliated with many other institutes, universities in the past and present and perhaps future. I'm not trying to get you in trouble with any particular employer. John has worked all over the world, and I myself have had the pleasure of encountering him at many different points in the world. John is an expert in many fields. He truly a renaissance man of ODR. He has a background in mathematics, in computer science, in law, in dispute resolution, teaching in business schools, and deeply invested, deeply involved in that community, and brings all of that to the world of ODR. Specifically, John has done a lot of the most interesting work on the notion of using AI in ODR for a wide variety of purposes. And I think that all of those kind of funnel in to what you'll be sharing with us today, this model, a model for a platform for incorporating AI to the fullest. And if I've misrepresented that in any way, then I'm sure you'll correct me. But John, thank you so much for being here. It's all yours. Take it away.
Thanks, Noam, and it is lovely being here. Now, what I'm going to talk about today is just using artificial intelligence to provide user-centric online dispute resolution. I have a lot more in my overheads, and I could go on for hours or even days. I will try and focus upon this one topic because I do have a habit of tending to go too wide and to waffle. And also, some of the overheads have often been made for people who are not experts in ODR. Now, all of you, by very much your participation in Cyber Week, are experts in the area. So you don't need introductory material about what ODR is. You probably know much better than me. However, I do, just to start off, I want to say the pioneers of online dispute resolution saw it as a futuristic idea that could cope with e-commerce disputes. And I know I remember meeting Ethan Katch in the late 1990s, and very futuristic, even very much a pioneer in the area, but he saw it as e-commerce. And there were a few practical systems. I don't think they're being terribly much used now, but again, most of them were academic papers. And I want to talk about how that has changed. Now, legal communities now realise the benefits of online dispute resolution. And particularly with the prevalence of COVID-19, we have had a real use. Often it's only been in terms of video conferencing, but of using dispute resolution over the internet. And also, I think people who can be really advantaged. In fact, I wrote a paper as early as 2002, and the reason for doing that was not so much that I had foresight, but the people I don't have a legal degree. I do know about law, but I don't have a legal degree. I've not been engaged in legal practice. The people who talked to me very much in the early days were at legal aid. And legal aid were very much interested not only in representing clients, but in educating clients themselves, because they didn't have the resources to represent everybody they'd like to. So I do believe that online dispute resolution is particularly useful for self-represented litigants. What you will notice on the bottom of every overhead is some references in smaller fonts and in green, plus some other comments. And as I said, this paper will appear in group decision and negotiation. I've got the reviews. I need to change it to meet those. But if anyone else wants to make comments to me, that would be great. So the benefits of using ADR and ODR, we all know that. That's why we're in the field. Efficiency, acceptance amongst key stakeholders, the cost of traditional legal recourse, and the time of trials. By the way, I ought to say a lot of my work has been with Noam, and even some of this very writing is due to Noam. So let's have a look at a timeline. And I'm always interested in history, because I think that can predict to you where we've come from, where we're going, and the next big wave. I mean, for example, about the US elections, to me, I see almost every US election as refighting the American Civil War, and it hasn't really been resolved. And until we do that, we're not going to be able to move on. So what about ODR? Well, ODR has its roots and starts with ADR. And ADR, whilst one can argue that it's existed for thousands of years, and if you're interested into the Jewish Torah, you'll find the instance of God negotiating with Abraham on Sodom and Gomorrah, and saying, well, Abraham, can you find 50 righteous people, and then I'll save it. Comes down to 40, 30, 20, 10. So it's the idea of a negotiation. But really, in the US, and the US as a world leader, ADR gained a lot of traction from the Pound Conference in 1976. You got the Harvard Program on Negotiation. You got Fisher and Urey's book on Getting to Yes, which is setting up principles of ADR. Pretty much the same time, actually, Taxman was formed McCarty at Rutgers in the 70s. The latent damage advisor was Richard Susskind's PhD thesis at Oxford in 1986, looking at legal expert systems to model legal decision making. So putting the expertise of a lawyer into a computer system. And at that stage, people really loved the idea that it could happen, but they didn't see it as terribly practical. 1990s, you got the development of the internet. 89, the first work at CERN and Tim Berners-Lee, but by the end of the 1990s, it was pretty widely available. And following that, you got initial proposals for online dispute resolution. Ethan Catch, Colin Rule, may have been others talking about that, but Ethan and Colin are the ones I know about really well. 2000s, you got the development of ODR for e-commerce. People started buying things on the internet, and you got eBay and PayPal and things like that. So ODR occurring, but in fact, primarily just for e-commerce. And then 2010, the last 10 years, you've got the development of practical usable systems. The two I'm going to talk about are Rechtwijzer, which I'm not sure is being that widely used now. There were times when it was. And the British Columbia Civil Resolution Tribunal, which is being very widely used and has been very successful, not necessarily because of the technology, but although the technology is very good, but because of the commitment of the courts and the government in British Columbia. So ODR has moved beyond e-commerce. It is being used for non-financial disputes. And I think Ethan and Orna's book, which I'd imagine most of you will have read, is really important for showing how widely ODR can be used. And also, and one thing that I think is incredibly important, maybe because speaking to the people at Kent Law School really got me involved in the area of self-represented litigants. We had a workshop there with the Artificial Intelligence Law Conference, which had been held in St. Louis, Missouri in 2001. And we decided, well, St. Louis was not a big enough, important enough legal area. So we went on to hold this workshop at the Kent Law School in Chicago, Kent. And as I'm talking to you, I'm thinking, and related to, at this conference in St. Louis, Missouri, there's always an annual dinner and you had to pay extra for the annual dinner. It wasn't part of conference registration. And I had taken 5 PhD students with me, and just finding the money from the travel from Australia to St. Louis was pretty expensive. And airline fees there were much more expensive than they are now. The Australian dollar was not doing well. So the keynote speaker was a congressman, not a congressman, was somebody who was in the Illinois State House. He had been a professor at the University of Chicago in the law school, and he'd moved into politics. And I thought, I'm not going to pay $36 a head to hear a nobody, and I didn't really think it was terribly useful. Well, I don't know if you can realise who this professor was. This was one of my major mistakes I made in not realising it. The name of the person who gave the keynote speech was one Barack Obama. So one can never be sure. Anyway, but now we've moved, so I think the Kent Law School has done a lot of pioneering work on self-represented litigation, on law and technology. It's not really been in the ODR area. So that's why I am emphasising this, because I think many of you may not be aware of the work of the Kent Law people. So the first system I want to talk about, I would now call this ODR, but we didn't even know ODR in 1995. What we wanted to do, the 1990s were the start in computer science and artificial intelligence of the work on machine learning. I mean, machine learning, data mining is now very, very common. It's used everywhere. You do it in undergraduate courses. You do data analytics. In 1995, almost all lawyers thought it was a waste of time. It could never be done, and it would not be useful. So what we wanted to do was to show that we could do machine learning in law. Now, the word ODR was not something we even knew about. We hadn't really been terribly involved in ADR. So we worked in the area of Australian family law, and in particularly wanting to analyse property distributions. We felt looking at the welfare of children was far too discretionary, and it would be very difficult to use it, but it was more process-oriented, less discretionary in property, although children and property are related. Anyway, so we wanted to build a system to show you could use machine learning. I will show you the system, and I think we were pretty successful. But the one thing we learned very early on is you can't just throw software at data. You need to understand the domain. you need to carefully, in fact, model the domain and build software appropriately. And what we decided was to use the theory of Stephen Toulmin, a British philosopher at Cambridge, who then went to University of Southern California to model the domain. I'll show you how in a moment. The research was viewed as very futuristic. Not only that, we got a lot of publicity, almost for the wrong reasons from an academic point of view, because the London Daily Telegraph were looking for story. And as you well know from the media, the more interesting a story is and the more far-fetched people believe it, the more they want to see it. So the London Daily Telegraph rang me. It was early in the morning of the 4th of July in Melbourne, but the 3rd of July in London, and they said, we would like you to run the software on the divorce of Prince Charles and Lady Diana, who were then getting divorced. This is, I'll go to the previous page earlier, but these are two articles on it. One was about the computer system, which was on page 14, and one was about the implications, how the software takes a hard line on the prince, and that was on page 1. And we initially, when I was phoned, I said, no, I don't want to do it because they're not an Australian couple and we model Australian family law, nobody else, which is quite different from Britain. And they said, doesn't matter, I want an answer. Then I said, we don't know the assets of Charles and Diana. The very reason they're not going to court is to keep the assets secret. They said, well, we'll tell you. And then we said, it's not a commonplace case. What we want is a garden variety nitty-gritty. Machine learning works far better on those sort of cases. Oh, that doesn't matter either. Anyway, they said, let's use it. Well, we did. And the interesting thing is it gave Lady Di 70% of the pool. And the reasoning was she was a single mother who had lost her job. Now, single mothers who lose their jobs do fairly well in the Australia, distinct to the distribution of property in the Australian family law system. Princess Di didn't fit into that sort of area. So 25 years later, just this year, Legal Aid in South Australia and others have developed a system that uses machine learning to do prediction on family law property cases with the idea that, in fact, it'll be used by people and will not have them going to the court. Now, the users claim that it leverages co-design, intuitive content and artificial intelligence to assist people to resolve their dispute themselves. And since being launched by the Australian Attorney General on June the 30th, over 1,000 people have commenced this process. It's probably higher today because I wrote these notes primarily for a previous talk about a month and a half ago. The portable, developer Portable, who'd been talking to me and do a lot of work in community work and law and technology. You can have a look at their Access to Justice project. But what I'm going to do is I am going to show you
costly business of deciding who gets what. Well, now couples who want to separate are being offered an alternative to lawyers, a computer program that divides their assets based on the contribution each partner has made to the marriage. More from Mark O'Brien.
I didn't think the split would be that large.
What the program is saying is that while that's true, but Perry worked around the house.
They're talking about the effort that both of us put into the marriage. And while you were out there working, I was here looking after the girls.
This couple, Brendan and Perry, have just found out who gets what if it all comes crashing down and they divorce. And who says? Not a judge or a court case, but this, a computer.
And how long have you been married?
7 years, a bit over 7 years now, isn't it?
7 years.
7 years.
Yeah, more than that.
It's called Split Up, the program which could change the way thousands of couples count their costs on the road to divorce. John Zeleznikow from Melbourne's La Trobe University came up with the idea after his divorce.
First of all, what we have done is we've spoken to expert lawyers about what are the criteria for the distribution of property. Having decided that, we have gone and taken 400 cases from the family court and coded them into the system.
In fact, the system is already making an international splash. John's program is only a prototype, but a London newspaper has had enough faith to call him to crunch the numbers for a couple who have had more than their share of problems.
It is announced from Buckingham Palace that with regret, the Prince and Princess of Wales have decided to separate.
She was certainly categorised as a working woman because even though she was not paid as most women in society who have outside jobs, even though she wasn't paid, she had very much a 100% job. As well as that, she has responsibility for her children.
So feed in the various royal trappings, properties, cars, school fees and personal jewellery. Over the weekend, Diana settled for about $30 million, although if it was up to the computer, she would have probably done even better.
He has very certain future job prospects. She has much less.
And so, according to the computer, Diana will get a right royal share.
The judgment was that Diana would receive 70% of the property.
Around the family court, it's often said by lawyers that a good divorce is one where both sides are a bit unhappy with the settlement. In Australia, the statistics on divorce are staggering. Nearly 40% of marriages fail, as 25,000 couples call it quits each year. Aside from the emotional trauma, splitting up is a multi-million-dollar business, but not everybody is convinced that a computer has all the answers for warring couples and lawyers.
I'd be concerned that if someone relied solely on this system, that it may not be accurate.
Leanne Kane, a family law specialist, says divorcing couples need the human touch, not a computer printout.
A family lawyer has a very important role to play in the conduct of a family law matter. They don't only take instructions and obtain and provide legal advice. What they will do is they will comfort the client, they will have some empathy, they will guide them through situations.
But don't they take into consideration that I've earned more?
So how would Brendan and Perry, who incidentally aren't getting divorced, stand if things did go bad? The couple has been married for 7 years and they have 2 young children. Andrew Strenieri is taking the couple on a trip they hope they never make.
Well, what the program is telling us that you contributed financially to the marriage at about the same level as each other over the years.
More, I would have done more. You have to have kids. Yeah, lots more.
Lots more. No.
A bit more.
And what about the household duties?
Yeah, I did listen to that as well. Oh, about the same.
So after earnings...
And you're working full-time at the moment?
Yeah.
Superannuation...
it's not due for quite a while, is it?
No.
And future job prospects...
And how many assets are in the business?
About 15 grand.
When all the factors are punched in, the results are a shock to Brendan.
What the program is telling us that you, Brendan, will get about 35% of the assets and you, Perry, will get about 65% of the assets. Now that's mainly because you have the children.
Yeah, well, that's fair.
It is like I would lose the vast majority. It would be like I'd lose the house. I mean, I'd keep the car in the back shed, but I'd lose the house. 35%. You're really obliged. You're really obliged, yeah.
One way to stop litigation is to be reasonably confident about the outcome beforehand. This system will offer good advice as to what is likely to happen if you litigate it.
You have any obligations?
And as for happily married Brendan and Perry, the academic exercise has been an eye-opener.
Marriage guidance is a better option, I got to tell you.
Bit of worry, Mark O'Brien report.
Okay, so that is 1995. It was not, in fact, ODR focused or oriented. By the way, the script had nothing to do with me. So the idea of them coming out and saying that negotiation is the better idea was coming from them.
Yeah.
Now, I thought that was really interesting to show you just as a part of where we've come from. Okay, so that was the split up project. Now, the interesting, going to go to another video in a minute, that's why. Okay, so the split up project really got us interested in negotiation, ADR, and then on to ODR. By the way, this is the scale of the Toulmin arguments. On the right, you get the percentage going to the husband. To the left of that is the contributions, level of wealth, future needs. That comes from a neural network, which is a statistical learning algorithm. How you determine contributions, level of wealth, and future needs. Two of those came from the neural networks of the little dots, come from direct contributions, indirect contributions, the length of the marriage matters, and the relative homemaker contribution. The value of the common pool matters because paramount interest of the children is first. The lower the common pool value is, the more important needs become. It's needs versus contributions. In a very affluent marriage, then everybody's needs get met, so contributions hence become more significant. And then you've got needs, and you work down the tree, you can work out needs, contributions, and further you go. The point that I want to make to you is not how you actually do that, because that'd take a lot of time for you to learn, but you need a sophisticated understanding of the domain to believe that you can just throw algorithms at data without the understanding of the domain is incorrect. Now, we continue doing that sort of work on ADR, ODR, building systems. And at that very time, we thought to ourselves, how can you use game theory to optimise people's performances in negotiation? And that has been pretty widely done. If you want to, and more about that will be done in the paper, but if you want to look at the work of Howard Rafer and others at the Harvard Program on Negotiation. And of course, the person who's very best known in this area is John Nash. Now, most people know John Nash because of the book about him and the film A Beautiful Mind. But obviously, he was a very significant mathematician. He got his PhD at Princeton, 1950, wrote his very important work in Econometrica, 1953. At the same sort of time, there was work by Thomas Schelling, and also more recently, John Aumann, and all of them finished up getting Nobel Prizes for their work on game theory and mathematics, but there is no Nobel Prize in mathematics. They got it in economics. Anyway, we thought doing trade-offs, can you use game theory to help? And so the next sort of project, I don't know whether you consider game theory artificial intelligence. I do, because it is fairly similar. So in fact, we developed a system also related to family law, but just as an application. And the reason we did that was to show, could you use game theory? And I'm going to show you a video there as well.
My favourite movie lines is from the movie St Elmo's Fire, where after a relationship breaks down and the woman is moving out, as she approaches the record collection, the man shouts, "No, Springsteen is leaving this house. You can have all the Carly Simons." I like it because it sums up all the pettiness and anger that comes out when people are trying to split up their joint property. If only there was a better way to do it.
If you had any experience of divorce, you would know how difficult it can be to decide who gets what in the split.
So we developed a computer software package to help divorcing couples work out their priorities and the fairest way to divide their assets.
Our software works by asking the couple to give a point value to the shared assets of the marriage.
For example, Martha and George have 2 kids, a family home, 2 cars and a prized record collection. First, each gives these assets a rating according to their priorities, taking into account both emotional and monetary value. Next, they rate the concerns related to each asset, such as keeping or selling the house, or their preference for the Beatles or Rolling Stones albums.
The software uses these ratings to mathematically allocate and trade off items so that Martha and George end up with the things they really want.
And it's not just for divorce.
Our software can be easily adapted to negotiate any dispute, from industrial relations to neighbourhood conflicts.
Please welcome from Melbourne Dr. Amelia Bellucci and Professor John Zeleznikow. Hi, John. Hi, Amelia.
Hi, Dave.
Now, if we take our mythical couple, Martha and Arthur, and they have a number of belongings, is the idea of this that if they can honestly say what they want and how much they want it, then instead of fighting over it in an emotional way, if they hand over their priorities to the artificial intelligence, i.e. your computer program, that will in a sort of logical, rational, detached manner try and maximise the satisfaction that both can get.
That is a very good explanation.
Is it?
And it leads to a very impressive, and it leads to a win-win situation because each of the parties gets what they want.
So, for example, in this program, you can see down here there's a number of sort of fictional items: a car, house, Beatles albums, Elton John, Rolling Stones, no Carly Simon.
Sorry.
And, you know, it's simply, at the end of the program, it simply allocates A gets this, B gets this, A gets this, B gets that.
Because that's what the parties have said they really want.
Yeah, right. Well, the end result is you can split the property. So that can go one way, that can go in the other, and we're left with the Mariner fleet of glasses, which clearly no one wants, so we'll leave there. Come over and sit down.
And the most important thing is that the lawyers get nothing.
Right, right. Well, it is a way of keeping the lawyers out of it.
Absolutely.
Yeah, definitely.
What do you think, Mark?
The first thing that comes to my mind is the biggest issue in any divorce is always the custody of the children. Does this software deal with that?
Yes. I mean, I know this is a very contentious issue, but the point is, even when you're arguing about children, and if a couple separate, they realise they can't spend 168 hours with both parents each week. So what you've got to do is decide, what do you mean by the children? Maybe the husband would feel more comfortable if his children went to a particular school or they went to a certain religious group. It lets people do trade-offs. However, I should point out, and we've done research in family law. Family law is about the paramount interest of children. It's about justice. This is a system that worries about issues-based negotiation, so it should never be binding.
If I were going to use this software, I would think the first thing I'd be concerned about is I'd be worried that the software was fair. How do I know when I'm using the software that this software is making equitable decisions?
Well, it's making decisions based on equitable principles that we're using.
And is this all sort of visible to me, so as I'm stepping through the process, I can understand how my own decisions that I'm making are being reflected?
Yes, to a certain degree, yes, because the first screen you see is, well, what you have to put into the computer system are the issues in dispute, and then you give them all a rating out of 100. All of them must equal 100. And so the other party does the same thing. And then the next screen we see some trade-off maps. And they basically, for me, it was like just getting people to understand that this is what you're really thinking about. Just by allocating all these numbers, these are the trade-offs that are really happening, even though you're not conscious of it.
Bernie?
Couples who are breaking up are really likely to be spiteful, and I'm just wondering, is it easy and possible for people to play the system to really kind of manipulate things so they get more?
No. If they want to stop their partner or their ex-partner getting one item, they're going to hurt their own interest.
Have you tried it with real couples?
We have, yeah.
How'd they go?
If you're talking about tangible goods, they tended to be pretty pleased. We found you generally get about 70 to 80% of what you want because you're not diametrically opposed.
Yeah.
It doesn't have to be a 50-50 split.
Yeah, Chris?
Can I ask you about perhaps an expansion potential for this into, for example, industrial relations or into other areas where people are in an adversarial situation, normally in a court? Do you think there are some?
I think there's a huge scope. So in the thesis I did an evaluation with industrial relations, and the solution that I came up with was very close to the agreement that they came to. So that was real fantastic. I was really happy with that result.
Summing up, Matt?
I think this is brilliant. I think if you offer it over the web, you're going to have a very good business and you're going to provide a lot of benefit to people.
Right.
Chris?
Yeah, I think the great thing about this, if nothing else, it introduces the concept of trade-offs rather than any absolute to these people.
I totally agree.
So whatever the figures are, they're at least beginning to think about trading things off, and that is so important in resolving those well. So terrific.
Bernie?
It's an enormous approach to a solution to such a fraught area, but I think it could be one part of getting towards that fair end that people want when they break up. So yeah, it's going places.
Please thank Dr. Amelia Bellucci and Professor John Zeleznikow for Well, who will win tonight? Well, tonight's winner will be in the running to be named our Inventor of the Year. Will it be the new flipper, the pod fins, the weed-destroying root blade, or the property-dividing family winner? Let's look first at originality. Chris Russell, what's the most original?
And our family winner is so innovative in its concept.
Yeah.
And I suppose, but it's very hard to balance that against something that's so original in its engineering design, which is pod fins. They're two different ways of being original, but yet so original.
Artificial intelligence applied to mediation in the past, so but applying it to this situation, which would have to be the most hideously fraught one that's possible. They've done an amazing job with that, but I agree, pod fins for originality.
Yeah. What about design?
Well, again, I think pod fins is leading in the design just because it's very elegant. Family winner, it doesn't look pretty yet, and when they get finished it'll be pretty and it will show people how their decisions are influencing how they balance.
Pie charts, everyone loves a pie chart.
Yeah.
I'd actually put a bit of vote in for a root blade for design. That's quite clever. Simple. It's a different shape. He's got a point, so you're not trying to cut through 16 roots across a wire. He's done a lot of things in there in design.
What about need? Which one of those three inventions does the world need the most?
A family winner that works. If that works, that is...
This is our must-have, should-have, could-have thing.
Yes.
And for me, the could-have is probably the root blade. The should-have is probably the pod fins, but the must-have, is family winner.
Let's find out our final episode winner for 2005. Chris?
I think I'm going to go with family winner on need.
Bernie?
Pod fins.
Mark Pesci.
The invention this week that just blew me away was family winner.
Yeah.
I think so.
Then there it goes, our final episode winner, the family winner, Dr. Amelia Bellucci and Professor John Zeleznikow. Congratulations, John. Congratulations.
Thank you.
You can hold that, both of you. Well done. Amelia and John are in the running to be named our Inventors of the Year. What do you think?
Okay, there we are. Now I've got the top chair. Okay, so what do you learn? What do we learn from that? Well, first of all, you get to see how I've aged. Okay, you can see me 25 years later, or you can see me 15 years ago, and then you can see my PhD students, both of them, interesting enough, and I'd never noticed it, are of Italian backgrounds. In fact, their parents were born in Italy. I've had lots of other PhD students who are not Italian. But the important thing is the gradual moving of where we're coming to. So now let's get more across to 2020. And let's get... Now, I did manage to look at the time. I can see at the bottom of my slide the time. And I'm going to very quickly go through the next set of overheads because a lot of them have been covered in other talks during Cyber Week. They're less on AI. Where are we? There we are. So one of the things, and in fact Noam and I have done lots of work on this, is for consumers to have confidence in ODR processes, you want to ensure fairness, trust, security, and appropriate governance. And a series of papers by Noam and myself, first in Hamline University's School of Law's Journal of Public Law and Policy, and then in Negotiation Journal on those sort of issues, and some work following the PhD thesis of a student of mine, Fahima Abidi, looking at those areas mainly in e-commerce related disputes. You will find lots of overheads on fairness, trust, security. I won't talk about that. What I will talk about that, so remain on the one sort of issue, is self-represented litigants. Mark Galanter at University Wisconsin at Madison says there's an abundance of data showing the number of trials, federal and state, civil and criminal, jury and bench, is really decreasing. Now, I know when I talk to non-lawyers, they can't believe it because they say there's so much more litigation. Yeah, but the litigation doesn't turn up in finally in court decisions. It is pre-court machinations. It is involved in negotiation. Now, there are more and more sort of self-represented litigants. I remember one paper where I think it was Maricopa County in Arizona, where in 88% of family cases, one of the parties was self-represented, and in 52%, both clients were self-represented. And this has problems. It causes delays, administrative costs, and undermines the judge's abilities to maintain impartiality, and can leave the unsuccessful litigant feeling as though they've been treated unfairly. I can remember some very early work with someone, Carl Branting, who'd worked at the US Supreme Court, and he'd found that in Idaho, because judges felt they had to be impartial, they weren't helping women with domestic violence orders. But, you know, when you're in a great need and there's a rush and you're being physically threatened, you need help. So the question is ODR a way of helping? Now, very early on in the ODR community, we tended to believe that, in fact, we wanted everything automated. As you notice, the systems I've been built are helping people negotiate, not to take over the process. Finally, after years and years of work, people are suddenly starting to ask themselves the question, what degree of automation should be used? And in fact, the International Association for Artificial Intelligence and Law had a workshop at their conference last year about looking at degrees of automation. Now, automated systems, if you look at the left, have got low cost and they're very efficient. But you get the lack of transparency and the lack of human involvement. And you'll notice about the two systems I showed you, we tried to have some transparency and some human involvement. And examples of systems, and the reason I'm giving the examples of systems is because what it does is it leads you into looking as to what are the principles for a model. So by doing a lot of case studies, you get a feeling for what's necessary. Now, the Victorian Civil and Administrative Tribunal, which is the low-level tribunal in Victoria, is developing online platforms and at various locations. Melbourne is the heart of Victoria, and it has about 80% of the population. People in rural areas, and Victoria's only a very small physical state, are disadvantaged. Having online platforms is great. parties not being required to travel is great. Documentation is securely uploaded and witnesses can attend a hearing by logging onto an online platform. So VCAT does very simple stuff, and you can really see this as case management. Case management is the essential first step. It's important, but it's nowhere near sufficient and certainly not complete. A very, very interesting tool I've heard about, and it's widely used in the USA, is Our Family Wizard, used by lots of family court judges. Now, initially, you may not even think of it as online dispute resolution. What it does is it's a tool that provides verifiable evidence of how parental communication takes place. So judges order that the couple use Our Family Wizard. What it does is it then forces you to engage in appropriate and civil behaviour, because it only lets you talk in a certain manner. It also records your discussions, and so if your discussions are inappropriate, that might come out to damage you if it gets to a court case. And it assists in developing parenting planning and maintaining a record of parental behaviour. So does it help you resolve a dispute? Not directly. Does it give you information? Does it let you conduct negotiations? No, but nevertheless, it's still extremely helpful and is an important part of the process. And certainly it's responsible for my thinking. Now, the Rechtwijzer System, and I do know a fair bit about it. And with my very early days, I went on sabbatical to Tilburg in the Netherlands and met the group there in Maurits Barendrecht, who was involved developing the system. The Dutch became very big on negotiation support, artificial intelligence and law, and online dispute resolution, because the then Dutch Justice Ministry said every Dutch law school is going to have a chair of law and technology. And so for 10, 15 years, the Dutch were doing a lot of work in that area. That money's been withdrawn. Some Dutch universities have continued doing the work, others have not. Maurits decided that he wanted to leave the university, and he went to The Hague to develop the Hague Institute for Law, and there they developed the Rechtwijzer System, which provided support for those engaged in Dutch family law conflicts. And it provided support for entering data and forms and advice about procedures and outcomes. I've already talked about Our Family Wizard, and there you have some references there. So the most important and significant system is the British Columbia Civil Resolution Tribunal, which tries and helps resolve low-level disputes like VCAT. So you go through a solution explorer. It diagnoses, provides legal information, templates. You can apply to the Civil Resolution Tribunal for dispute resolution. Will help you fill out forms, help you attempt to resolve a dispute. If you can't do that, it'll go to a facilitator. And if you can't do that, it goes to an independent member for arbitration. Agreements can be turned into enforceable orders. If negotiation or facilitation doesn't lead to a resolution, you get an independent member making a determination. So it's really med-arb different. You're trying to mediate. If you can't mediate, you go to arbitration. It deals with generally small issues, motor vehicle injuries up to 50,000, that's Canadian, small claims, strata or condominium or owners corporation property, societies and cooperative association disputes, and shared accommodation and housing. Now, the interesting thing is, and this has got a lot to do with the digital divide, because the British Civil Resolution Tribunal has said for these 5 issues, you can only use the Civil Resolution Tribunal. You've got to do it online. There are no paper-based solutions available. So people argue, what about digitally disadvantaged litigants? Well, if you are digitally disadvantaged, then you can get accessing the internet and using the software, but you are compelled to use the software for these disputes. And it's been successful because British Columbia residents are mandated to use the system. They cannot go elsewhere for the help. And so because of that, it has been incredibly successful. Now, what do users of ODR want? Users want it to be effective, fair, available 24/7, and can be utilised through what they've got, and in particular for social media. Courts and governments, they want it to be effective and fair, but they also want it to be cheap, which the users, I suppose, don't worry about that much, and also to enhance justice. So this is really the crux of what I'm trying to get to is, what does the ideal system look like? Where should we be going? And it's almost a puzzle of the following 6 areas. Any dispute at the start, and the VCAT system and a lot of the online systems only do one: case management. Is case management important? Obviously. It is. The system has got to allow users to enter information, ask them for appropriate data, and provide for templates to initiate the dispute. The interesting thing is, even until a year or 2 ago, Victoria Legal Aid were doing a lot of their input sessions over the telephone. So you get somebody phoning in, often very stressed, talking to a telephonist, phoned to a ear, typing in the information about the case. They might get the spelling wrong, the people's names wrong, date of birth wrong, addresses wrong. Why can't somebody enter the information themselves? Why can't someone find where the case is? All of these, I think we would all agree that case management's the essential first step. But a very important second step is triaging. Look, some cases are incredibly important. They've got to be dealt with now, 5 or 10 minutes, certainly not in weeks or months. You might suggest domestic abuse is a problem. You might suggest homelessness, lots of issues. So you need to be able to triage. You need to know where something is going to be sent very quickly and to whom it gets sent to. Third point, and this is really what I've been talking about during this session, but it's still important, is the system should advise tools for reality testing. What are these tools could be? They could be books, they could be articles, they could be reports of cases, copies of legislation and videos. I mean, I think there is nothing as important as seeing a video of bad behaviour, because none of us ever believe we're behaving inappropriately. The idea is, and these are sort of issues of bias, we think of ourselves as the reasonable people and the others have not. So a video is really important. The one example I think of, I don't know if any of you ever saw a 1989 film called The War of the Roses. My wife and I went along and saw it, and she said, oh, this is until she became a family dispute resolution practitioner. At those stage she wasn't. She said, no, nobody could be like that, the Rose family in that film. It is overblown and overdone. My concern, on the other hand, was my God, it's too realistic. I didn't enjoy it because I thought, yeah, this is what people can do. So the answer is, it is much easier to see what you consider reasonable and unreasonable behaviour when you watch other people. There also should be calculators, such as advice on child support, property distribution. So many people spend a lot of time on very simplistic stuff. There ought to be calculators, BATNA advisory systems to inform disputants of the likely outcome. Normally when I give a talk and I focus on law, I talk a fair bit about bargaining in the shadow of the law. I haven't here because of time, and I showed you the videos. So knowing what would happen if the dispute were to be decided by decision making, because one of the reasons you negotiate is because you'd rather make the decision yourself rather than have someone else make it, but it's useful to know what decision that someone else would make. The fourth, number one, the case management, that is, everybody agrees. Number four, almost every ODR system has communication tools, really, and that's what people are focusing now, even in the days of COVID-19. But there need to be negotiation, mediation, conciliation and facilitation skills to discuss. Really helps with shuttle mediation, can provide you with a trace of what you've done. And this is what we tend to focus on there. I know I built a system with Relationships Australia in Queensland, and all they wanted to do, because they wanted to emulate face-to-face mediation, and all they wanted to do were communication tools. So 4 is being done. 5 is really coming out of my work on Family Winner. And a lot of people can accept that they need to negotiate. They know what the law is. They can put down the principles. So they've got 1 to 4, but they can't actually, not good in doing trade-offs. Well, what I'm suggesting is that you can use some game theory or AI to facilitate trade-offs. So you know what the two parties want. You put them into algorithms to provide advice as to how they get trade-offs. Then number 6, and this is essentially speaking to mediators, is finishing. I've heard so often that people agree in principle, and particularly in telephone dispute resolution sessions, they reach an agreement, and then when the practitioner sends in an agreement for signing, they said, no, this is not what we agreed upon, because they'd agreed upon principles. So you can develop drafting software once a negotiation is resolved in principle to get suitable agreements. Now, no single dispute system will necessarily require all processes. Anyone will require 1 and 4. They then might want a combination of 2, 3, 5 and 6. But to have a system doing that would be great. The problem is it would be probably quite expensive to build this. Why is this even more important? And golly, I'm seeing, even in Australia, so many providers of what they call ODR, whether it be iMediation or Modron or things like that. And that's because we have had this terrible pandemic. Was it foreseeable? Bill Gates, obviously very prominent with regard to Microsoft, but he'd been predicting this. Pandemic had been predicted, and the really bad news, and that's why I don't think a vaccine may solve this problem. It's not going to solve all problems because there'll be other pandemics. There had been previously, there'll probably be more in the future. All we've tended to worry about is, in fact, communication systems, that there's going to be a greater and greater need for ODR and ODR beyond case management and communications. And what I've been trying to do in today's talk is merely talk about those things.
As John has said, this paper will be published in Group Decision Negotiation. He's happy to share a copy. You know where to find Professor John Zeleznikow, Victoria University at Melbourne. And with that, I'd like to wrap this session. I'll invite you all to come join us tomorrow at the final session, the final day of Cyber Week. Thank you so much, John. Thank you, everybody.
Thank you. No, great seeing you and great seeing the others.
Always. Take good care.